To begin the discussion on amendments, we will ask, what was the intended purpose of amendments? Today, some so-called experts are claiming we can fix the federal government's violations of our Constitution by amending the Constitution. So let's think about their claim. If your spouse violates the marriage vows, will your marriage be saved if you amend the vows to permit adultery? When motorists violate the speed limits, will safety be restored if we increase the speed limits? When people violate the Ten Commandments, if we amend the Ten Commandments to permit the sins, will morality be restored? Of course not. The solution is to obey the marriage vows, obey the speed limits, obey the Ten Commandments, and obey the Constitution we already have. Our Constitution delegates only a handful of enumerated powers to the federal government. But for 100 years, the federal government, the state governments, and the people have ignored these existing constitutional limitations on the powers of the federal government. So when people in federal government violate the Constitution and their oath of office by spending money on what is not authorized, and by making laws on what is not authorized, how can amending the Constitution rein them in? Furthermore, and contrary to what the so-called experts are telling you, our framers never said that when the federal government violates the Constitution, the solution is to amend the Constitution. What our framers actually said is that the purpose of amendments is to correct defects in the Constitution. Elbridge Gerry said on June 5, 1787, "The novelty and difficulty of the experiment requires periodical revision." Alexander Hamilton said on September 10, 1787, "Amendments remedy defects in the Constitution." Hamilton also said in Federalist No. 85, 13th paragraph, that useful amendments would address the organization of the government, not the mass of its powers. And James Madison said in Federalist No. 43 that amendment of errors and useful alterations would be suggested by experience. Accordingly, after the first 10 amendments were ratified, the next few amendments actually did correct defects in the Constitution. The 11th Amendment reduced the jurisdiction of the federal courts by taking away from them the power to hear cases filed by a citizen of one state against another state. The 12th Amendment fixed a glitch in the process of electing the president and vice president. The 13th Amendment fixed the defect of slavery. Section 1 of the 14th Amendment extended citizenship to freed slaves and protected them from Southern black codes, which denied them basic God-given rights. The second point to make is that amendments can be dangerous. Many of the existing amendments increased the powers of the federal government. The 13th, 14th, 15th, 16th, 17th, 18th, 19th, 23rd, 24th, and 26th Amendments expanded federal powers over the states and the people. Many amendments proposed currently by some so-called experts also increase the powers of the federal government over the states and the people. They do it, for the most part, by legalizing practices which are now unconstitutional. The proposed balanced budget amendment is a classic example. On February 13, 2013, U.S. Senator John Cornyn offered a balanced budget amendment. To the desperate general public, this sounds like a very good idea. But let's take another look and see if it really does what it says it will do. This is Section 1 of his proposed amendment. Take a minute to read it and see if it does not say, "We will not spend more than we take in, unless, of course, we vote to spend more than we take in." Here it is. Lots of words, but that is what it says. It can also mean the more we take in, the more we can spend, right? Let's get to the second section of his amendment that he claims will balance the budget. Take just a minute to read it and see if you can find any similarities to Section 1. Here it is. Starting to see the pattern here? Mr. Cornyn says they will not spend more than 18% of the GDP unless they vote to spend more than 18% of the GDP. This sounds really good since he makes the point that we are now spending 23% of the GDP. However, the percentage figure does not really matter now, does it? Here is the second and more important point to be made. Isn't limiting Congress to 18% the same thing as granting them permission to spend up to 18%? Of course it is, because, as you have learned, there is no authority in the Constitution to spend any percentage of the GDP. The only spending authorized in the Constitution is linked to the subjects Congress may address. But now, because of this amendment, spending would be linked to something other than the subjects they may address, the GDP. So, this is no restriction at all, but a completely new constitutional authority to spend. So, with Cornyn's proposed amendment, Congress would have authority to spend money on anything, on any subject it pleases, and all spending would become constitutional and lawful. How cool is that? As a result, this little section just transformed our Constitution from one of limited enumerated powers to one of general and unlimited powers. That's the exact opposite of the concept of enumerated powers, and also the opposite of how it was presented to you. Now, let's look at an amendment written by another person who is considered to be by some, and especially him, an expert constitutional lawyer. The purpose he gives for offering this particular amendment is to limit the federal bureaucracy. Let's see if it really limits the bureaucracy. Here is the text of the amendment this expert offers. Quote, all federal departments and agencies shall expire if said departments and agencies are not individually reauthorized in standalone reauthorization bills every 3 years by a majority vote of the House of Representatives and the Senate. Close quote. On a first reading, it sounds pretty good. The impression is that we can now get rid of those unconstitutional administrative agencies we mentioned earlier. But as long as Congress periodically reauthorizes these agencies, they remain, don't they? How does that limit the bureaucracy? So instead of limiting the bureaucracy, it legalizes it. The third point to be addressed about amendments is that they provide additional fodder for federal courts to pervert. Article 3, which we discussed earlier, states in part, quote, the judicial power shall extend to all cases in law and equity arising under this Constitution. Close quote. Once an amendment is ratified, it becomes part of the Constitution. It then arises under the Constitution and becomes subject to the opinions of the federal courts. And we have no idea how the federal courts will interpret the amendment. Let's look at 2 ways the federal courts perverted Section 1 of the 14th Amendment. The original intent of Section 1 was to extend citizenship to freed slaves and to protect them from Southern black codes which denied them basic God-given rights. But the Supreme Court redefined words in Section 1 in order to legalize abortion and homosexual marriage, which had nothing whatsoever to do with citizenship of freed slaves and protecting their God-given rights. In Obergefell versus Hodges, which the Supreme Court decided in 2015, they looked at the term equal protection in Section 1 and asserted that state laws which restrict marriage to one man and one woman violate the Equal Protection Clause. So the Supreme Court redefined liberty and equal protection to get them to mean what they needed them to mean to justify the result the court wanted in the cases before them. The Supreme Court also fabricated the incorporation doctrine in order to dictate to the states respecting First Amendment issues. Recall, the first words of the First Amendment tell us that it prohibits Congress from making laws establishing a religion, prohibiting the free exercise of religion, or abridging freedom of speech or the press, the right of assembly, and petition. But the Supreme Court fabricated a theory where they asserted that Section 1 of the 14th Amendment incorporated the First Amendment, so that the Supreme Court now had judicial power over how the states handled First Amendment issues. As we saw in the last section, that is the theory the Supreme Court used to ban Christian prayer in the public schools and order the removal of crosses and nativity scenes from the public square. The fourth point to address about amendments is that amendments have unforeseen consequences. We have no idea how the courts will interpret these amendments years from now. Who could have predicted that the First Amendment would be used to silence Christian speech in the public square throughout the United States? Who could have predicted that Section 1 of the 14th Amendment would be used to legalize abortion and homosexual marriage? Who could have predicted that the 16th Amendment would be used to control the speech of our priests and pastors? In order to obtain a 501c3 tax exemption, the churches had to submit to the speech codes established by the federal government. Look at the 17th Amendment. Because the American people did not know what the Federalist Papers say about why state legislatures should elect the 2 U.S. senators for their state, they were easily deceived into supporting the 17th Amendment. As a result, state sovereignty, for the most part, bit the dust. Still think we can solve our problems with amendments? To sum up this section, when we hear people proposing amendments, know this. 1. That those who we are told are experts make amendments that do not do what they claim. 2. That amendments can have disastrous and unforeseen consequences. 3. That if history is any indication, any new amendments would create more opportunities for the federal courts to pervert the Constitution. Darrell Royal was a very successful football coach at the University of Texas. Look at amendments like Darrell Royal looked at passing the ball instead of running. He said, quote, "I've always felt that 3 things can happen to you whenever you throw the football, and 2 of them are bad." Close quote. As you have seen, our federal government has stepped far beyond their lawful reach into our private lives. Each time they go beyond their constitutional authority, we surrender a fractional part of the exercise of our natural rights. When our federal government usurps power and acts in a tyrannical manner toward the states or the people, what did our framers really say that we must do as a remedy? Here's what they did not say to do. Not one recommended amending the Constitution. Not one founder recommended that states or the people file a lawsuit. However, when watching the news, you will see almost weekly stories on state attorneys general who do exactly that. Just because these elected officials hold important jobs does not mean they are the most constitutionally literate, the most moral, or correct. When you look at it, our elected officials must have only one rule book, the Constitution. Our Constitution is a lawful document which created the federal government. All elected and appointed officials took a personal oath on their honor to support it, not to vote their conscience or to bring home the bacon. The long-term answer lies in the reason you are here today. and it's not amendments, no matter how good they sound. We have given 3 clear reasons not to propose amendments, and those reasons are beyond dispute. The framers advised several remedies, 2 of which are nullification and the election of more faithful and virtuous representatives. These are not the most glamorous, nor eye-catching, nor are they short-term, but they are the safest and surest, and much closer to the people as the founders intended government to be. There is a distinction to be made between abuses of delegated power and the usurpations of power which have not been granted. For abuses of delegated power, like the passage of unwise bankruptcy laws, then election of more virtuous and better representatives is the answer. For abuses of power which has not been delegated to the federal government, like health care, then nullification is the proper answer, according to Madison, Hamilton, and Jefferson. We use their own words to prove it. We have already touched on the selection of more faithful and virtuous representatives when we covered the oath of office, and how the only requirement we demand of our representatives through the oath is to support the Constitution. Now we turn to the subject of nullification and our founders' recommendations, what they actually said as opposed to what we are told they said. It must be noted here that there are some who oppose the simple act of nullification. You will have to be the judge as to why they oppose it. Here, our job is to tell you, in their own words, what the founders said. You would be absolutely astounded at how many legislators are opposed to nullification, despite it being the easiest to do, not to mention the safest. You have already seen the dreadful and unpredictable consequences that amendments can have when you do not have legislators that are as constitutionally and legally astute as our founders were. Nullification simply means we refuse to do it. Who can nullify? States, counties, cities, towns, and communities, and we the people. Here is a reminder of the purpose of our government as provided by our founders. The purpose of civil government is to protect our God-given natural rights. Civil government is legitimate only when it operates with our consent. Since the U.S. Constitution forms the federal civil government, it operates with our consent only when it obeys the Constitution. When it does not obey the Constitution and takes away the exercise of any of our natural rights, we have the right and the duty to alter, abolish, or throw off such government. However, this is not what many of your elected representatives in our state capital believe. And some of them who do not believe in nullification are accepting advice from those far less educated on the Constitution than you are, but who pretend to be experts on the Constitution nevertheless. If you were to personally visit your representative and ask him about nullification, the chances are the response would surprise you. Many well-respected people say that nullification by states of unconstitutional acts of the federal government is somehow unlawful and or impossible. I have heard it said in our state's capital by legislators in positions of power that nullification is a dirty word. Really? They have not been listening to the wisdom and experience of the founders. Most of these so-called expert advisors seem unaware of the 2 conditions which our framers said must be present before nullification is proper and possible. First, the act of the federal government must be unconstitutional, usually a usurpation of a power not delegated to them. Second, the act must require the states or the people to do or not do something. This is an important distinction, as you will see. Here are 3 illustrations showing when both requirements are fulfilled and when nullification is a proper option or not. Example number 1. When the act of the federal government is unconstitutional and orders the states or the people to do or not do something, like laws which require citizens to register arms, or laws which prohibit students from praying at school, or laws which force the people to purchase health insurance. None of these subjects are matters the federal government has any authority to address, and the acts require the states or the people to do or not do something. Since both requirements are fulfilled, nullification is proper and possible. Example number 2. When the act of the federal government is unconstitutional, but does not order the states or the people to do or not do something, as in the Alien and Sedition Acts, then nullification is not possible. The states may interpose by objecting, but cannot nullify. This is what happened with Virginia and Kentucky resolutions. Both Hamilton and Madison acknowledged that fact in subsequent papers shown in your handbook. Interposing in this case is when the states get between the federal government and the people. Nullification is simply one form of interposition. Example number 3. When the act of the federal government is unjust but is constitutional, nullification is not possible. An example of that is the Tariff Act of 1828. South Carolina wanted to nullify it, but they couldn't because Article 1, Section 8, Clause 1 delegates to Congress the power to impose import tariffs called imposts. Opponents of state nullification tell us that Madison opposed nullification and said so in this case. Of course he did. South Carolina wanted to nullify a constitutional act. The states may interpose by objecting and getting the legislation changed, but cannot nullify, and Madison knew that. When lawyers speak of court rulings or precedents, you have seen that the concept of natural rights is not a consideration. Nullification by the people or the states is not some paltry constitutional right. It is a natural right of self-defense. But these so-called experts, and at least one Supreme Court judge, as you saw earlier in the program, are simply not tuned in to something we call natural rights. It's amazing to see how far we have come from the Founders' world.
To stop the feds, people generally try 3 things: vote the bums out, sue in federal court, or demand Congress repeal the law they passed in the first place. But if you want to succeed, you should do something else. Think of the Constitution like you would an owner's manual for something in your home. While some of the jargon might be a little confusing, if you have questions, you should go to the people who wrote it for clarification. Sure, James Madison doesn't have a toll-free number or live chat, but the man considered by many to be the father of the Constitution wrote plenty about how to stop the federal government when it won't follow the document he was so instrumental in writing. In a paper known as Federalist Number 46, James Madison told us exactly what to do. He provided a blueprint of sorts, a series of actions to effectively stop the feds. But what Madison did not advise might be even more notable than what he did advise. He never told you that your first or primary strategy should include the 3 things people normally do today. That is, voting bums out, suing in federal court, or demanding federal politicians repeal federal laws. None of these were part of what James Madison advised as a first response to federal overreach. Did you know the man considered by many to be the father of the Constitution gave us a blueprint for what to do when the federal government doesn't follow the rules? Well, he did, and it's not something they teach you in school either. When ratification of the Constitution was still up in the air, James Madison and others wrote a series of papers about how things would work. In one, Federalist Paper number 46, Madison laid out a clear plan, a blueprint for what was needed to keep the federal government in check when words on paper wouldn't do the job. Surprisingly, James Madison didn't advise using as a first response to federal overreach what are known as the most vaunted parts of the American system today. That is, voting bums out, suing in federal court, or demanding that federal politicians repeal their own laws. Instead, James Madison advised a series of 4 actions by individuals and states. 1. Protest on a large scale. Madison called it disquietude of the people. 2. Noncompliance. Madison recommended disobedience in general and a refusal to cooperate with officers of the Union. 3. Outspoken governors. Madison advised what he called frowns of the executive of the state to build awareness in the general public. And 4. State legislation. Madison said legislative devices should be used in the states, that is, passing resolutions or bills as needed to counter federal power. James Madison told us that using these steps together in multiple states would be extremely effective against the federal government. He wrote that doing so would present obstructions which the federal government would be hardly willing to encounter. This advice was written in a time when the federal government did very little. Today, when the federal government is active in nearly all areas of life, James Madison's blueprint will have far more impact and success than it did in his day. That's because Washington, D.C. relies on support and cooperation from the states for almost everything. As the National Governors Association put it, states are partners with the federal government on most federal programs. Partnerships don't work too well when half the team quits. In other words, if individuals and states protest and refuse to participate on a wide scale, there's very little the federal government can do about it. In 1798, Thomas Jefferson and James Madison penned the Kentucky and Virginia resolutions, formally articulating the principles of nullification for the first time. During the summer of 1798, Congress passed 4 laws, together known as the Alien and Sedition Acts. These laws represented a gross exercise of power never delegated to Congress. In response, Thomas Jefferson drafted the Kentucky resolutions, and the state legislature passed a revised version of them on November 10, 1798. Asserting that the several states composing the United States of America are not united on the principle of unlimited submission to their general government, Jefferson proclaimed that nullification was the proper response to deal with all federal overreach. In his original draft, he wrote, "Where powers are assumed which have not been delegated, a nullification of the act is the rightful remedy. That every state has a natural right in cases not within the compact to nullify of their own authority all assumptions of power by others within their limits. That without this right, they would be under the dominion, absolute and unlimited, of whosoever might exercise this right of judgment for them." On December 24, 1798, the Virginia Senate passed similar resolutions penned by James Madison, further asserting not just the right, but the duty of states to step in and stop the federal government. He wrote, "In a case of a deliberate, palpable, and dangerous exercise of other powers not granted by the said compact, the states who are parties thereto have the right and are in duty bound to interpose for arresting the progress of the evil and for maintaining within their respective limits the authorities, rights, and liberties appertaining to them." Taken together, the Kentucky and Virginia resolutions lay out the principles of nullification. That is, state-level resistance as a duty to stop federal power. Civil disobedience and non-compliance are not just for individuals. By withdrawing support and resources, states have a powerful tool to stop federal acts. American history is filled with stories of heroic individuals defying government laws, from Harriet Tubman and the Underground Railroad to Susan B. Anthony and Claudette Colvin. Even the father of the Constitution, James Madison, advocated resistance to unjust laws. As Madison put it in Federalist 46, when a number of states pass laws directing state agents to refuse participation in a federal act, coupled with individual disobedience on a wide scale, this creates a climate the government would be hardly willing to encounter. But that was then, and this is now, right? Wrong. In Madison's time, the federal government was so small no one alive today would recognize it. And even then, withdrawing consent by refusing to participate on both an individual and state level was effective against federal acts. So today, withdrawing support and consent is far more effective. Think of it this way. Doing the dishes sure is easier if you have one person washing and another person drying. But if your partner stops helping, you can still get it done without too much trouble. On the other hand, try moving a couch up a flight of stairs and into a dorm room without help. You might pull it off on your own if you're really determined, but you're not going to want to do that ever again. Today, the federal government is huge and involved in nearly everything. It relies on our help more than ever. A statement from the National Governors Association confirmed this. They noted states are partners with the federal government on most federal programs. Partnerships don't work when half the team stops participating. By withdrawing support, states can effectively bring down most federal programs. Both Thomas Jefferson and James Madison recommended being strategic about stopping federal power in the states. But they differed in what qualified for the strongest level of resistance. In 1798, Thomas Jefferson advised each state to take measures of its own to ensure that federal acts not authorized by the Constitution would not be exercised within their respective territories. Jefferson felt that any time the federal government went beyond the Constitution, each state should immediately take steps to stop enforcement of such acts. He said each state should nullify of their own authority all assumptions of power by others within their limits. But Jefferson was no dummy. In a letter to James Madison, he advised being strategic about it too, suggesting they push as far as events will render prudent. James Madison was even more pragmatic. Writing in Federalist 46, he recommended a refusal to cooperate with officers of the Union. The Supreme Court repeatedly supported this as the anti-commandeering doctrine in a series of cases from 1842 to 2012. Madison only recommended going beyond mass non-participation and using a more confrontational approach in extreme situations, while Jefferson was willing to go as far as strategically possible on any federal act perceived to be outside the scope of the Constitution. The goal for Jefferson was to stop the enforcement of such federal acts within the boundaries of the state. Today, James Madison's pragmatic approach can effectively achieve Thomas Jefferson's goals. The federal government is involved in so many areas of your life, it has to rely on states to carry out most federal programs. Because of this, states have a powerful and effective strategy at hand. They can take measures of their own without having to get permission from anyone outside their state. They can use a refusal to cooperate with officers of the Union, backed by modern Supreme Court precedent, to effectuate a practical nullification of most federal programs. But if such methods fail to stop federal power, the principal author of the Declaration of Independence and the father of the Constitution both agreed that stronger steps should sometimes be taken. As James Madison put it, nullification by any means necessary is the natural right, which all admit to be a remedy against insupportable oppression.
Let's sum up what we have covered. We hope you are leaving with a different understanding of our founding documents. Here's the summation. Number 1. The Constitution is not a self-enforcing document. The Founders left it completely up to us. 2. If you have questions on meanings in the Constitution, the Federalist Papers are the most authoritative and primary source to consult after the Constitution itself. 3. We are not a democracy. We are a republic. Number 4. Supreme Court opinions are not the law of the land if they are contrary to the Constitution as intended. Number 5. It is an error to say we have constitutional rights. The Constitution confers no rights to anyone. Number 6. God-given rights enjoy an elevated status and are not subject to amendments or court opinions. Number 7. The founders looked at the states as we look at nations today, free and independent, not just subunits of the larger nation. Number 8. We considered the importance of the oath of office. Number 9. The concept of enumerated powers is not an easy concept to absorb quickly. Number 10. The President can issue executive orders, but only on those subjects he is authorized to address. Number 11. The President can sign treaties, but only on the subjects he is authorized to address. Number 12. Amendments in the past have been used by the courts as tools to rule on our natural rights. That's all, folks. Thank you so much for your time.